In this video, I will be outlining the major court cases in which our rights to privacy were challenged in. Some of these court cases will deal with controversies such as abortion and the right to same-sex marriage. First, we have to understand that our right to privacy would not be as important today if it had not been for Justice Louis Brandeis. In 1916, Louis Brandeis was nominated to the United States Supreme Court by President Woodrow Wilson. Brandeis and his law partner Samuel Warrant published The Right to Privacy, which became the first major article to advocate legal privacy rights. By emphasizing the Fourth Amendment, which prohibits unreasonable searches and seizures without a warrant, Brandeis supported every individual's right to privacy in cases such as Olmstead v. United States. In Olmstead v. the United States, Roy Olmstead was convicted for smuggling and selling alcohol in violation of prohibition. To gather evidence against him, the government wiretapped Olmstead's office phones without first obtaining a warrant. Olmstead argued that the police had violated his Fourth and Fifth Amendments by doing this. The Supreme Court ruled that the government could use the evidence obtained from the wiretapping. Justice Brandeis attacked this ruling by arguing that there is no difference between listening to a phone call and reading a sealed letter, that the government should not violate the laws of the states to gather evidence and then use the evidence to prosecute people. With this dissent from Brandeis, the Supreme Court overturned Olmstead's ruling in the future case Katz v. the United States. In Katz v. United States, Charles Katz was charged with conducting illegal gambling operations across state lines in violation with federal laws. To gain evidence against him, the FBI placed a warrantless recording device outside a telephone booth. Katz appealed the conviction by claiming the evidence in which they had collected inside a protected area, the telephone booth, violated the Fourth Amendment. The federal agents countered this by saying that a public telephone booth was not a constitutionally protected area, which would allow them to go through without a warrant. The Supreme Court ruled in favor of Katz because placing a recording device without a warrant on a public telephone booth was unreasonable search that violated the Fourth Amendment. Katz was entitled to assume that his words would not be broadcasted to the world when the doors of the phone were shut. Now, this case is very important because if the Supreme Court had ruled in favor of the FBI agents, we would not be entitled to assume that we have the rights to speak freely inside the doors of our house and to have privacy when doing this. Other cases that have dealt with the privacy of sex and homosexuality include the Stanley v. Georgia case, the Griswold v. Connecticut, Bowers v. Hardick, and Lawrence v. Texas. Now, I will briefly outline the rulings of these cases in the backgrounds and how they have a major impact on our right of privacy when dealing with homosexualities and sex-related topics. In the case of Stanley versus Georgia, Stanley was convicted of bookkeeping, an act in which a person takes illegal bets on sporting or other events. Well, to find evidence against Stanley, the police searched Stanley's home, and instead of finding bookmaking things, instead they found dirty movies, obscene movies, and Stanley was charged and arrested for possessing these obscene materials. Stanley argued that criminalizing him for the possession of obscene materials violated his First Amendment, which was the right to free speech. Well, the Supreme Court ruled in favor of Stanley because they agreed that states did not have any business in telling a man sitting alone in his own house what books he may read or what films he may watch. The Constitution prohibits making mere possessions a crime as well. In the case of Griswold versus Connecticut, Ms. Griswold, an executive director of the Planned Parenthood League of Connecticut, was convicted of advising a married couple about birth control and ways to prevent conception. Griswold argued that the people have rights to privacy against government intrusion. She supported her stance by using the Ninth Amendment, which said citizens have more rights even though they aren't specifically listed in the Constitution. The Supreme Court ruled in favor of Griswold because they concluded that birth control fell under the category of privacy. In the case of Bowers versus Hardwick, Michael Hardwick and his partner were convicted and arrested for violating Georgia's sodomy statute. Now, without making this weird, I will try to explain what a sodomy statute is. A sodomy statute is basically a law that bans any act of unnatural sexual activities, such as bestiality. Well, Hardwick argued that the sodomy statute violated his right to privacy, that he could do as he pleased inside the bedroom of his house. The Supreme Court ruled that the rights for gays to engage in sodomy was not protected by the Constitution. They claimed that the act of sodomy was deeply rooted and was a great offense in the 13 original colonies. Further on, the Supreme Court stated that the act of sodomy cannot be protected by the right of privacy either, simply because it may occur inside a house. They backed this up by saying that although possessions of illegal drugs may occur inside a house, it is still a crime. And this ruling was overturned in the future case of Lawrence versus Texas. In the case of Lawrence versus Texas, Lawrence and his partner, just like Michael Hardwick and his partner, were fined and convicted for having same-sex sexual intercourse. Lawrence argued that the Texas sodomy statute was in violation of the Equal Protection Clause of the 14th Amendment, which states that all persons under the Constitution will have an equal protection of laws. And the Supreme Court ruled that the statute of Texas in fact, violated the 14th Amendment's Due Process Clause. The court also declared that the ruling in Bowers' case was misguided because it focused more on whether homosexuals had the right to engage in sodomy rather than the right to have privacy in their homes and the right to freely engage in consensual adult sex. Although these four major cases brought in equality for the privacy of homosexuals, the real victory did not occur until DOMA, Defense of Marriage Act, and the Proposition 8 of California were uplifted. The Defense of Marriage Act, or DOMA, was a law made to protect the beliefs of gay rights activists. By defining marriage as an act between a man and a woman, DOMA denied any federal benefits for gay couples whose marriages were recognized at state level. The Proposition 8 clause of California banned same-sex marriages in California. The two cases, U.S. versus Windsor and Hollingston versus Perry, helped the Supreme Court realize that the DOMA Act and the Proposition 8 were unconstitutional because it violated the basic rights of any individual. The laws were then overturned on a federal level, and although states can still choose whether to legalize or illegalize gay marriages, the fact that it's prohibited to illegalized gay marriages on a federal level was a great victory inside the homosexual community, because it meant that they had the rights to decide what they want to do with their relationship without the government headbutting inside their problems. One of the major court cases that dealt with the privacy for abortion was Roe v. Wade. Norma McCorvey, best known for her fictitious name Jane Roe in Roe v. Wade, was a woman in Texas who wanted to have a legal abortion when facing an unplanned pregnancy. Although she never had the abortion, pro-abortion feminist attorney Sarah Weddington used McCorvey's case to overturn Texas law making abortions legal. Weddington argued that the Texas law was unconstitutional against the right of personal privacy. She argued that a woman's choice in deciding whether she wants to have her baby or she doesn't should not be intervened by the government, because it was her choice, it was her body. And Wade's argument against that was that there was life in the fetus, and there was life from the moment of conception. So to have an abortion would mean to take that life away, and that would be homicide. And the state had an interest in forbidding that. The court ruled that a woman's right to an abortion fell within the right to privacy, which was protected by the 14th Amendment, and the decision uplifted the ban of abortion in states and gave women rights to have abortions. This case was important because it would be used to look back on to determine the ruling of future cases for abortion, such as the Planned Parenthood versus Casey case, in which Pennsylvania passed an abortion control act that required women to give informed consents before having an abortion and opposed them to wait 24 hours before seeking abortions. It also required minors to have parental consent before going through the abortion process. When the court ruled this, they looked back on Roe v. Wade and realized that a woman had the right to privacy when making these choices. So the courts had new standards concerning abortion regulation and said that any new regulations that may impose a burden to a pregnant woman was invalidated. The courts only required women to notify their husbands before undergoing the procedures. Another case in which Roe v. Wade had a big impact on was the Webster versus Reproduction Health Services. In this case, Carhart, a doctor, challenged the Nebraska law which prohibited partial birth, or a birth in which a physician partially delivers an unborn child before killing the fetus and completing the delivery, illegal. He claimed the law to be in violation of a woman's right to an abortion as deemed in Roe v. Wade. So the Supreme Court ruled that the Nebraska's ban on partial birth was unconstitutional for that reason. So if it had not been for the court case Roe v. Wade, women would not be able to choose whether they want to keep the child or they want to have an abortion, and they would not have the privacy rights in which they make those decisions in. This is why the court case was very important. Apart from our privacy rights dealing with sex, homosexuality, and abortion, our rights right now are being challenged by the National Security Agency. Since the 9/11 incident, the National Security Agency, which is responsible for collecting data and information for foreign intelligence and counterintelligence purposes, has really stepped up their game. They've taken actions to secure the United States from terrorist attacks by collecting data on cell phone calls, including the number, location, and duration of the call's participants. They also are able to collect a ton of data from the internet, our internet usage, and people who are against the actions of the National Security Agency do so because they feel like it's a threat to their right to privacy. They don't want anyone to see what's on their computer or see what's on their phone. And those who are for the National Security Agency argue that the program is critical in protecting the nation from terrorist attacks. We have to know, for example, in the Boston bombing, we were able to pinpoint the suspects of the bombings because of security cameras, and if it had not been for those security cameras, who knows how long it would have taken us to figure out who was responsible for this chaos. Another hot topic that occurs when we talk about privacy is the right to die and assisted suicide. The right to die is a controversial topic because it challenges our right to privacy and our right to die on so many levels. Those who are for these rights do so because they argue that if a person is terminally ill, meaning that there's no chances of them surviving, then they should have the right to decide whether or not they want to continue on. And that choice to live or die shouldn't be ours, it should be the hospital's, and the decision in which the family makes for the patient, or the patient makes for his or herself, should be private. And those who argue against these rights do so because they believe that if a person is able to breathe on a life support system, then they should continue on to live because there's still hope. They also argue that letting family members decide whether the incompetent patient should live or die is not right, because if the family member's relationship with the patient is not as great as it should be, then the motive for taking out the life support system would not be good. It would be for a negative motive, and that causes problems. In the case of Karen Ann Quillen and Cruzen versus Director, Missouri Department of Health, we can see these two sides of the argument going head on. In the case of Karen Ann Quillen, Karen Ann Quillen was a girl who had been in a coma for 10 years after a fatal incident. Her parents pleaded that the doctors disconnect the respirator that was allowing their daughter to live so she could die with grace and dignity, because there was absolutely no hope that she would recover. When the hospital refused to do this, her parents sued, and the court ruled that her father, and not her doctors or the courts, was in authority of deciding her fate in her behalf. The court also ruled that no one could be criminally liable for removing life support systems because the woman's death would not be homicide, but rather expiration from existing natural causes. In the case of Cruzen versus Director, Missouri Department of Health, we have the opposite idea going on. In this case, Nancy Cruzen was involved in a car crash that left her in a vegetable state, which meant that she could not do anything, and she was sustained on a life support system for several weeks. And when Cruzen's parents attempted to terminate the life of the life support system, the hospital refused to do so without court approval. So the court ruled, and it ruled in favor of the Missouri Department of Health, because they found that the state of Missouri's action was designed to preserve human life was constitutional, and because there was no guarantee that the family members would act in the best interest of the incompetent patient, the courts upheld to the Missouri's requirements. In conclusion, if it had not been for Justice Brandeis in the Olmstead versus United States case, then we would not be able to speak freely in private without the government intruding on us. And if it had not been for the 4 major cases dealing with homosexuality and sex, we would not be able to act freely in private on our choices when we're inside our house and who we want to be with without the government stepping in. And if it had not been for Norma McCorvey in the Roe versus Wade case, then women would not be allowed to have a choice in deciding whether they want to keep their kids when giving birth. And that would be a huge invasion on privacy for women. So basically, all these cases have helped formed the views of privacy in which we live in today, and cases such as the National Security Agency and the cases on assisted suicide are continuing to help us form the ideal idea of what it means for us as individuals to have privacy rights. And that concludes the video today.